After Clause 4, Baroness Lister Burtisham.
My Lords, I rise to move Amendment 11 and thank the noble Baronesses Lady Ludford and Bennett of Manor Castle and the noble Lord Woolley of Woodford for their support. The amendment will extend the right to register as citizens to the descendants of Chagossians exiled from their homeland, subject to a time limit. I'm grateful to Rosie Lebec of Biot Citizens for her help with it and Chagossian Voices for their briefing. In order to understand the case for the amendment, a bit of history is necessary. Back in the 1960s and early 1970s, the inhabitants of the Chagos archipelago, a British overseas territory which became part of the British Indian Ocean Territory, were evicted by the then British government in order to make way for a US airbase on Diego Garcia, the largest of the islands. They have never been allowed to return. Not only did they lose their homeland, but their grandchildren and other descendants have no right to British overseas territory citizenship and therefore to British citizenship. Only those born on the islands and the first generation born in exile have such a right. I should perhaps make clear that the right to citizenship should not be confused with a quite separate right of return, which is not affected by this amendment, important as it is. The Chagossians were deported to Mauritius and the Seychelles, and now around 4,000 live in the UK. But because of the unjust citizenship rules, many are undocumented, and children have been and continue to be deported. Families have been broken up and communities are divided, as some members have access to citizenship rights while others do not. This has caused hardship for many and has aggravated the trauma associated with exile. The lack of citizenship rights has created insecurity and made it harder to integrate into local communities. In the Commons, in committee, the Minister Tom Pursglove expressed some sympathy for the case made for the extension of citizenship rights and acknowledged that, I quote, the Chagossians present a unique case. He said he would reflect further. It all looked rather hopeful. But when Conservative MP Henry Smith raised the issue at report, what looked like a half-open door was slammed shut by the Immigration Minister Kevin Foster, which was very disappointing. Mr. Smith emphasised the anomalies created, the injustices caused, and that we're talking about no more than a few hundred to the low thousands of people who would benefit. So far, Biot Citizens have identified 500 descendants. So what is at stake is a small concession, but one which would make a huge difference to the lives of those affected, and which would also have symbolic importance for people who have lost their homeland through no fault of their own. Mr. Smith's amendment was rejected in a single paragraph. There would appear to be two strings to the government's case. The first is that the amendment would, I quote, undermine a long-standing principle of British nationality law, under which nationality or entitlement to nationality is not passed on to the second and subsequent generations born and settled outside the UK and its territories, creating quite a major precedent. Well, I'm sure noble lords can spot what a specious argument this is in this context. The only reason the Chagossians in question do not meet this condition is because they are descended from people who were evicted against their will from British overseas territory. Forced and continued exile prevents them from meeting these long-standing conditions. It's not clear that the government really understands this. But as the junior minister acknowledged in committee, it is a unique case, so no precedent would be set, unless the government had planned to evict others from their British overseas territory homelands. I hope and trust that if the noble lady, I think it's the noble lady, the minister, has been briefed to use this argument, she will scrap it now. The second government concern is more credible. They do not want to create an open-ended right in the way that the Commons Amendment did, and that, I think, is reasonable. This amendment therefore creates a 5-year time limit for applications following the Windrush precedent in the British Nationality Act 1981. Those aged under 18 at the time of enactment will have up until the age of 23. My Lords, I'm offering the Minister an opportunity to add something positive that would be widely welcomed to a bill that, with very few exceptions to be found in this part of it, has been widely condemned. If this particular way of capping entitlement is not to the government's liking, I am, of course, open to discussions about alternative means, such as a generational cap. I very much hope that the Minister will accept the amendment or a revised version of it for report. Would she be willing to meet virtually with me, other signatories of the amendment, and those advising me to discuss how we might proceed? Because I do plan to return to the issue at report so as to try to put right what Henry Smith MP correctly described as an appalling injustice. I beg to move.
After clause 4, insert the following new clause as printed on the Marshall list.
My Lords, I thoroughly endorse what the Noble Lady Lister has said, and I'm very pleased to co-sign this amendment. We've talked in the first two groups that we discussed this morning a lot about righting injustices. This is an opportunity to right a gross historic wrong of forced eviction and exile, which was indeed ruled illegal by the International Court of Justice in 2019. I was one of those who raised this issue very briefly at second reading. I don't think the Noble Lady the Minister referred to it in her response, though I know she had a lot of issues to cover. Although it should be noted that the amendment in the other place by Henry Smith MP, the Noble Lady Lister referred to at report stage, had a very sizable support of 245 members, displaying the strength of feeling about the trauma and hardship of the Chagossian community that Lady Lister referred to. The cross-party, all-party group on Chagos is a strong and active group which has long campaigned to right, insofar as is possible, the wrongs of the 1960s, when, having resisted independence from Mauritius, of which Chagos was part, Britain secretly acceded to an American request to make one of the islands, Diego Garcia, available on a long lease as a, quote, communications hub, because it later became notorious as a site for rendition flights. Anyway, the then British government of, I'm afraid, Harold Wilson, detached Chagos from Mauritius and then emptied Chagos, chucking out its inhabitants. This appeared apparently to be compensation for declining to get compensation for the Americans for the UK declining to get involved in the Vietnam War. Anyway, the saga is littered with lies and bad faith. The UK told the UN that the Chagos Islands had no permanent population and that the Chagossians were merely contract labourers. So the British Indian Ocean Territory, or BIOT, comprising all the Chagos Islands, was detached from Mauritius, and between 1968 and 1973, the entire population of Chagos was removed. Some 2,000 people deported to Mauritius, the Seychelles, and some arrived in the UK, particularly in Crawley, perhaps because it's near Gatwick in Sussex. As was discussed this morning, the purpose of Part 1 of this bill is to address long-standing discrimination in British nationality law. And I would put to you that put to the House that Amendment 11 fits perfectly in this context. The original appalling injustice of the late 60s and early 70s, perpetrated against the Chagossians, has been compounded ever since, not only by their continuing enforced exile from their homeland, but by the deprivation of their descendants of their citizenship rights. Had they not been evicted, but had stayed in BIOT, they would have passed British Overseas Territory citizenship from generation to generation, and some would have had the entitlement to be registered as British citizens, or at least benefited from the Home Secretary's discretion to so register them. As the Noble Lady Lister said, ministers in the other place have provided no justification for resisting the rectification of this injustice suffered by Chagossians. It simply relies, the government simply relies, in a sense, on the injustice of eviction to perpetuate the injustice. Because we chucked them out, they weren't BIOC citizens, and so they can't benefit from any subsequent citizenship rights. The government now has an opportunity with this new clause to make substantial amends, hardly complete amends, but substantial for the wrongs done half a century ago. And I suggest that it is wrong to seek to assert that correcting the nationality law consequences of this wrong would create any wider precedent, as the noble lady said. If anyone wants to read, by the way, the history of the UK's perfidious treatment of the Chagossians, I recommend this booklet of a lecture by Professor Philippe Sands, QC, entitled Chagos, the Last British Colony in Africa, A Short History of Colonialism, a Modern Crime Against Humanity, ? And I will give this to Hansard so they can correctly identify it. So I urge the noble lady, the Minister, to give a positive response.
My Lords, I apologise for not being able to speak at the second reading. I rise now to support very strongly Amendment 11, which has cross-party support. I speak as a Vice-Chair of the All-Party Parliamentary Group on the Chagos Islands. My noble friend, Baroness Lister, has powerfully and clearly explained the position of this small number of people whose ancestors were wrongly deported from their island homes and who have been caught up in big power politics, which has denied them basic human rights, which we in your Lordship's House all enjoy. And the noble Baroness Lady Ludford has given thee the whole context. The fact is, my Lords, that although all UK governments agree that the exile of the Chagossians from their island homes 50 years ago was wrong and unjust, the present one continues not to allow resettlement, citing a range of reasons, including conservation, financial, feasibility, security, and defence for continuing this injustice. This is irrespective of the fact that it is well known that the American base on Diego Garcia is not threatened or impeded by resettlement on the 54 outer islands. Indeed, the UK government is committed in its 1965 Lancaster House Agreement to returning the territory, I quote, to Mauritius when no longer needed for defence purposes. The outer islands are not part of the defence framework. Conservation could be maintained by the Chagossians, as happens in other marine conservation areas, and there are various avenues for assistance with resettlement costs. It is political will and respect for human rights that are lacking. This government is acting also in defiance of the UN Charter in respect of decolonisation, United Nations General Assembly resolutions, and contrary to the opinion of the International Court of Justice and the decision of the Tribunal of the UN Convention on the Law of the Sea in its obdurate refusal to countenance resettlement for this, I repeat, very small number of people. And the all-party group strongly supports the international rule of law and the right of return. In respect of this amendment, which follows from all the events that we've set out, we firmly believe that until resettlement is permitted, Chagossians should not have to endure the further injustices loaded on them, which this amendment would remove: separation of families, deportation, and the unreasonable costs of excessive fees. Amendment 11 would at least go some way to ameliorate the acknowledged injustice Chagossians have endured by their exile, for this very modest amendment to be adopted by the government.
As I did this morning, express great sympathy for the point of view expressed by, so eloquently and passionately by the Baroness Lister. And as she rightly said, the amendment that was put down in the other place was voted down because it did contradict one of our long-standing, century-long principles for who becomes a British citizen. But as she pointed out, the new amendment deals with the point that was made in the other place I think, by putting a limit on the applicability of the proposal, which is good. So I think we are in a better place than we were then. And also, as she says, she's offering to talk, if possible, if there's any other way forward for this problem. And it is, I'm also a member of the all-party group on Chagos Islands, and I have great sympathy for their position. It is indeed a terrible plight and terrible evil deed that was done to those people. There are only, we're talking about possibly 500 people now in this particular context. There's more Chagossians from history, but there's only about 500 people in this particular category at the moment. The real villain, of course, here is not my noble friend, the Baroness, will be glad to know, the Home Office, but the Foreign Office. Frankly, they behaved disgracefully. The International Court of Justice, when it examined this, voted 116 to 6 against us. I mean, 116 to 6, for heaven's sake. You can't hardly have a bigger majority. I suppose you could have 192 for 1 or something. And that's how many nations there are in the United Nations. But it is a comprehensive defeat in the United Nations. Not only that, as has been pointed out by previous speakers, the United States government is helpful on this matter, and also the Mauritian government has pointed out that it's willing to give a 99-year lease to the United States government if it wishes to carry on having a base on the island. So every base is covered, frankly. There is really no case for the Foreign Office to resist doing the right thing. And it is costing us, frankly. It is costing us in the international arena. I mean, we're so completely in the wrong on this issue. I happen to read, I'm a bit of a nerd in this respect, I happen to read Sir Alan Dunker's diaries. Probably the only person in the floor who read Sir Alan Dunker's diaries. Oh, another one over there. Quite interesting, too long, but nonetheless quite interesting. But he does indicate the contempt with which the Foreign Office hold this point of view. They simply say, this is the International Court of Justice's decision was an advisory one. Well, we know it's an advisory one. Well, why don't they take some advice? Why don't they take some advice for once? You know, this is doing us huge damage internationally, and there really is no downside to agreeing to a new deal to the Mauritius government, to acceding to the demands of the Mauritian government and dealing with the Chagossian case. So it is not ultimately the responsibility of my noble friend on the front bench, she'd be glad to know. Nonetheless, I do think there is here an issue which the government could grasp at the right level and should do so.
My Lords, I would like to congratulate the noble Lady Baroness Lister and also Baronesses Ludford and Bennett and the noble Lord Woolley for laying this amendment. It is not an issue that I was familiar with until it was brought to my attention, but it does seem to me that it is one that I'm hoping my noble friend on the front bench will see herself able to take seriously and address. I understand that the 2002 British Overseas Territories Act granted British citizenship to Chagossians who were resettled, but only if they were born between the 13-year window 1969 to 1982. And that seems to have left families divided, such as Jean-Paul Delacroix, born in 1968, the oldest of all his siblings, and at age 64, he wants but cannot obtain British citizenship. His siblings can, and having been refused, he is now here illegally and cannot even work to support himself. In 2017, my honourable friend in the other place, Henry Smith, laid a private member's bill, which has still only had its first reading, and then again he laid the amendment that has been referred to by other noble lords to this bill in the other place. And as has been said, and I find it very difficult to understand this argument, the government's rationale for rejecting their right to British nationality relies on the actual cause of the injustice when refusing to correct it. So, having forcibly resettled these 3,000 individuals at the time, the injustice seems to be being compounded by refusing those small number of people who really want, and I would argue deserve, to be in receipt of citizenship, that opportunity. And this bill seems to represent a chance for the government to act on a long-standing injustice. Amendment 11 would correct the nationality law consequences of exiling the Chagossians, and only those born there or born in the window can currently claim citizenship. But the Noble Lady Lister's amendment would give the opportunity for all those who were born there. And the 5-year time-limited window, I think, tries to address the government's concerns, which, like my noble friend Lord Horam, I do understand. But the Chagossians do represent a unique case. It's hard to see this setting a precedent, and I would urge my noble friend to consider this concession before report.
Lady Bennett of Manor Castle signed the amendment and has asked me to speak in her place as she's unable to be here at the moment. This is obviously a 50-year-old injustice inflicted by the UK, by the Foreign Office, as Lord Horam suggests, and therefore it might have been good to have a Foreign Office Minister here to answer our points. What was done to the Chagos Islanders, a deprivation of their lands, dispossession of their community, chaos brought to individual lives, and it wasn't limited to 1 or 2 generations. It's gone on and on. And true reparations would involve the right of return. This is not special circumstances, not special treatment. This is justice that we are able to actually deliver, albeit very, very late. Simple justice ensures that we take responsibility for people whose lives we took control of without their consent. I very much hope the Noble Lady the Minister can take this back and ensure that it becomes part of the bill.
As may I declare my interest as a founder member, and like the noble Baroness Whittaker, a vice chairman of the Chagos Islands all-party parliamentary group, and having once had the pleasure of meeting the Chagos Islanders based in Mauritius, I rise to strongly support this amendment, as the noble Baroness Lister and the noble Lord Horam have explained. This issue is an international scandal for which the government is entirely responsible.
Didn't have the opportunity to speak at second reading, and I apologise for that. I also declare my interest in the register and want to clarify that I'm speaking in a personal capacity, and I'll keep my intervention very brief. But I agree with every single speech that has been made today, but I particularly want to reference some points made by the noble Lord Horam. I gave a speech at the Mauritian Foreign Ministry in 2019 in advance of the United Kingdom's court case. And while my speech was wide-ranging about international affairs and Britain's role in the world generally, I was astonished by the strength of feeling that the people present, mainly civil servants working in the Foreign Office, felt about this issue. They were not people who were affected by the Chagosians' claims themselves. Some were, some weren't. But the national sense of disbelief that a law-abiding, rules-abiding, great power in the world was behaving in this shabby manner towards a very small number of people. But I want to pick up one point in particular that the noble Lord Baroness Lister raised, which was about the reason given in the House of Commons for the Minister to say that he wouldn't support the amendment moved there. And that was because he said it would overturn and set precedent over years of British nationality law. My simple response to that is that increasingly, and particularly as we are bringing rights back home, as the government would profess in terms of its assessment of the Human Rights Act and so on, that if we're bringing rights home, then the noble lady will know very well that increasingly our courts are taking account of precedent of what a minister's intentions are when they speak in both Houses of Parliament, Parliament's intentions when they decide to do whatever they decide to do. So should she have similar concerns to the concerns expressed by the Minister in the House of Commons about setting precedent, all she would need to do when this bill comes back to the Chamber at report is to make it clear in her speech that she doesn't intend this act, a humanitarian act, to set precedent in any other way. And that's all she has to do to reassure the House, and the courts will take account of that. So I hope she will listen to the speeches across the House today on this matter with great sympathy, because that is what the small number of people deserve from us.
My Lords, as we have heard from my noble friend Baroness Ludford, the Chagos Islanders were evicted by the UK government in the late 1960s and early 1970s to make way for a US naval base, and they are still exiled from their homeland. And I'd say to the noble Lord Horam, there are two separate and very distinct issues here. One, as the noble Lord quite rightly says, is giving the Chagos Islands back to the islanders, which is very much an issue for the Foreign Office. This amendment is about giving Chagos Islanders nationality, and that is very much the responsibility of the Home Office and not the Foreign Office. And I would also say, in response to the last speaker and to the noble Lord, century-long precedents are not necessarily good precedents. One impact of the eviction has been to deprive descendants of their citizenship rights. The Chagos Islands remain a British overseas territory, and were it not for the eviction, as we have heard, they would have passed British overseas territories' citizenship from generation to generation. In certain circumstances, they could have acquired entitlement to be registered as British citizens. And since 2002, they could have benefited from a general discretion from the Home Secretary to register as British citizens. As the noble Lady Baroness Lister of Bertosset has said, the government's objection in the other place does not hold water. The situation of the Chagos Islanders is unique. And whilst the other measures in this part of the bill to address historic injustices are welcome, they are incomplete without the noble Lady Baroness Lister of Bertosset's amendment, which we wholeheartedly support. As the noble Baroness explained, it is narrow in scope, focused exclusively on Chagos Islanders, direct descendants, and limited to a 5-year window, either from the date the amendment comes into force or 5 years from when the person eligible turns 18. The Minister will have to do more than simply to repeat the words of her colleague in the other place to convince noble lords not to pursue this matter further at report.
I'd certainly like to express our support for this new clause, and just to be clear about what its objectives are, and to read from the member's explanatory statement, it says, this amendment would allow anyone who is descended from a person born before 1983 on the British Indian Ocean Territory to register as a British Overseas Territories citizen. They may also register as a British citizen at the same time. Both applications will be free of charge. The application must be submitted within 5 years, or in the case of a minor born before the date of coming into force, before they reach 23 years old. As we've heard, the new clause is intended to rectify a long-standing injustice which impacts descendants of the Chagos Islanders who were forcibly removed from the British Indian Ocean Territory in the 1960s. And I too would certainly too wish to express my appreciation and admiration of all those who've been raising this issue and pursuing it over a number of years, and not least my noble friends Baroness Lister of Berthset and Baroness Whittaker, though I know they are not the only ones who have been working on behalf of the Chagos Islanders. The issue does have significant cross-party support, and indeed the case for this change was powerfully made by a member of the Minister's own party in the Commons, Henry Smith MP, who was supported by members across that House. And the clause, as I've indicated, would extend the right to register for citizenship to the grandchildren and other descendants of this population, and it would, as has been pointed out, apply to only a small number of people. Now, in the Commons, the Minister's response was not too encouraging, suggesting that this would be too significant a departure from existing law. He did, however, say that the government had heard the strong points made and would, quote, continue to consider what more we could do, in going on to say, particularly giving the low uptake of the £40 million Foreign Commonwealth and Development Office Fund designed to assist this diaspora community. And we will certainly be keen to look at that and potentially at how it could allow those people to settle here in the United Kingdom. And I simply ask the noble lady the Minister what consideration of this issue has since occurred across government, and what have ministers settled on as to, quote, what more we could do, close quote. We've raised significant concerns in recent years over this government's ongoing foreign and defence policy as regards the Chagos Islands, and this bill does provide an opportunity for a distinct and limited change to our own law, but one which would have a significant impact for those affected following half a century of injustice, and who surely are a somewhat unique case, and not really, frankly, setting a precedent, which is what seems to have been argued by the government to date.
My Lords, can I thank all noble lords who've spoken in this debate, and I hope that noble lords will feel at the end of my response that I at least have given a partly positive response. And I'm aware that noble Lady Ludford didn't refer to it at second reading, but I'm very grateful for the discussion that we had, I think only yesterday, about this matter and others, and I found that very, very helpful. And I do understand as well the strength of feeling being expressed. I both sympathise and empathise with the residents of the Chagos Islands in terms of how they were treated back in the 1960s and 70s. And I also agree with the noble Lady Lister that return and citizenship are two different matters in relation to the Chagossians. We do recognise that some of the former residents of what is now the British Indian Ocean Territory missed out to on rights to British nationality when legislation was last passed to address the nationality of the Chagossians back in 2002. Section 6 of the British Overseas Territories Act of 2002 granted British Overseas Territories citizenship and British citizenship status by descent to any child born on or after 26th of April 1969 and before January 1983, where their mother was a citizen of the United Kingdom and colonies by virtue of her birth in the British Indian Ocean Territory. This measure reflected the removal of the Chagossians from the British Indian Ocean Territory and the fact that the British Overseas Territory citizen's mother couldn't pass on their citizenship to a child born outside of the UK or a UK territory. But the Chagossian community has criticised this provision because it did not provide for circumstances where women left the British Indian or Biot territory before the 26th of April 1969 in anticipation of being required to leave, nor did the provision allow children to inherit citizenship from an unmarried BOTC father. So I am pleased to say, and this is the partly positive response, that in response to these concerns, the Nationality and Borders Bill currently makes provision to extend BOTC and British citizenship rights to any second-generation Chagossians excuse me, who were not able to acquire citizenship through their mothers or unmarried fathers due to discrimination in nationality law. The issues are complex, with some family members in the same generation as one noble lord pointed out holding British nationality, while others do not. And I do agree with my honourable friend, the Minister for Safe and Legal Migration, who has stated in the other place that the government is keen to consider what more we can do to support these families seeking to settle here under the current system. Minister Foster has said that he's open to considering how we might use the FCDO £40 million fund in support package to support the Chagossians settled in the UK. But I must point out the position that successive governments have expressed on this point, that new clause 11 would undermine the principle in our nationality law that applies to all other descendants of British nationals, that the second and subsequent generation born and settled outside the UK and its territories don't have a right or entitlement to register as a British national. And I know that the Noble Lady's Amendment has sought to limit the right, as she said, to register as a British national to current generations who must apply within a limited time frame. But this doesn't alleviate the government's concern that offering this right is contrary to long-standing government policy, and it does go further than the rights available to many other descendants of British nationals settled elsewhere around the world today. On her request about meeting her and others interested in this point, of course I will, as I always do, follow up on Noble Lord's request, and I'm very, very happy to meet with her. On my noble friend Lord Horan's point, we will consider, of course, what further we can do to address concerns in the immigration rules. And on my noble friend Lady Altman's point about citizenship, of course, those without citizenship become overstayers, and they're complex issues. And we are very happy, as I said to my noble friend Lord Horan, to see what happy to consider what more we can do through the immigration system.
Before the Noble Lady, the Minister, sits down, could I just ask her briefly, in the light of the really eloquent and compelling speeches made in this debate, whether she concedes a distinction between people who leave a territory to settle elsewhere and people who are forcibly evicted from that territory?
Well, I don't think anybody in this committee would say that what happened to the Chagossians was by any means an acceptable position for them personally, and I don't think I was trying to make the case for that either.
My Lords, first of all, I'd like to thank everyone who contributed to this debate. I think it's fair to say there was unequivocal support, perhaps not for the exact wording of the amendment, but for what the amendment is trying to achieve. And that was across the House. People spoke very strongly. And actually, it's unusual when there's nothing said in opposition to what's trying to be achieved. I mean, the Noble Lady, the Minister, expressed her sympathy, her empathy, but I'm afraid that butters no parsnips when it comes to what the Chagossians want, and rightly want, because as people have said, this is a question of justice, it's a question of human rights. And my noble friend Lady Chakrabarti asked a very pertinent question about the distinction between those who choose to leave British territory and those who are forced out of it. And the Noble Lady, the Minister, has accepted that that was a wrong, that this country has to be, whichever government was in power, and I know it was my party, but never mind, we share the shame for that. And here is an opportunity. We're not putting it right, but we are at least trying to do something tangible that will go some way to putting one aspect of it right. So I'm desperately disappointed that the government is still using that argument that because the Chagossians are in the wrong place, they can't. This is a long-standing principle of British law, but what other group of people have been forcibly evicted in this way? And as I said, we're not setting a precedent because I'm assuming that we're not planning to evict anybody else in this way. So I thank the noble lady for the offer of a meeting. Perhaps we could take a sort of cross-party delegation because to reflect the strength of feeling across the House. But I do hope she will think again, because if not, I will want to bring this back to report. I mean, I have to admit, my noble friend Baroness Whittaker has been has been supporting the Chagossians for many years. I'm relatively new to the issue. It is extremely complicated, the legal position, and I may not have got it completely right. But there is a principle here, a principle of justice, a principle of human rights, which I think has been recognised across the House, and I really think that we must use this legislation to put this right, and there's no better place, as has been said by a number of noble lords, than this part of the bill, which is about putting right historical discrimination in nationality and citizenship law. But having said that, I will withdraw the amendment. I beg leave to withdraw the amendment for now.
Is it your Lordship's pleasure that this amendment be withdrawn? The amendment is by leave